Sorry, Judge.
That's okay. All right, we are streaming live then. So we got that taken care of. The time is scheduled for motion for other acts evidence. I was going to bring a few matters to the party's attention, just in the way of housekeeping for what's going on. The first thing is, Ms. Bender, I don't think we must have your current address because the last thing we sent to you came back in the mail. Can you give us your current address?
Yes, it's 4607 Pierce Street Northeast, Columbia Heights, Minnesota. I have to look up the zip code, sorry. 607.
You have 55421.
Yeah, the zip code, yep. I did call the court, clerk of court, and updated my address with him.
Yep, it looks like it must have just got updated now too, because we got it to the right address now, or we've got the right address. Thank you. It's a time schedule for motion for other acts filed by Mr. Verbatim. But as far as a couple of things, look at the jury plan that we have for Ashland County. We'll need to follow that. Jury selection is going to be off-site, so I'll meet the attorneys and parties at the off-site location. I don't have that address off the top of my head, but it's part of the jury plan for Ashland County. Because of that, we're not going to be really able to address any other pretrial issues other than just taking care of jury selection off-site. So if there's other issues, certainly get it on for hearing or something prior to the jury trial date, because we're not going to be able to do it before we pick a jury. We're going to have to pick the jury first and potentially address any other issues. A few things that I'll tell you about the voir dire and just kind of how I deal with things here in my court is probably not much different than how you guys address it in other places, but the one thing, I don't want the interaction with the jurors, and I don't think it's really going to happen anyway because of COVID. Be aware of that. We're going to try to keep the jury kind of in the one location, but everybody's going to be socially distanced. There's going to be masks for everybody. Exceptions can be made depending on witnesses testifying, what their comfort level is. We'll try to do, sanitize as much as we can. I don't know if you've been to the Ashland County Court, but it's a little bit on the narrow side, but it is a longer courtroom, so that should be good. For voir dire, I require the attorneys to introduce their witnesses to the jury. I'm hoping that they might not necessarily be present for jury selection, but at least mentioning their names so that the jurors know who they are. I will allow note-taking unless I hear an objection. Hearing no objection, the jurors will be allowed to take notes once they're selected. As far as objections go, don't argue in front of the jury, state your grounds, and then I'll deal with the objection. If you feel there needs to be a further record, we can either go and do it during a break, or we can do some type of sidebar or back behind the courtroom. We're going to try to keep the jurors in the courtroom just because it's one of the few places we can keep them socially distanced. And as far as the time to take, we're still thinking 2 days, Mr. Verbatim.
Your Honor, 2 days should be plenty of time to try the case.
Okay, Ms. Perrin, you agree?
I believe so.
All right, and then as far as voir dire goes, I'm not sure what the setup looks like because I haven't been there yet either, but just be aware, try to be speaking into whatever sound system they have. Don't ask the jurors about their general interests or hobbies. Don't try the case during voir dire. Don't ask hypothetical questions. Do not ask conversational or visiting questions. designed to establish rapport with the jury. Don't ask the jury of a pledge of any kind. And then if there's any particular questions you want me to ask the jurors, other than the standard that I basically use from the bench book, let me know or send those to me. It just is something in particular you prefer not to come from you, but to come from me. I have no problem asking additional questions. I'd rather not have, if the attorneys don't think it's something that will look favorably if they ask the jury, I can certainly do that. So you can send that to me, set of proposed jury questions you want the court to ask, other than the standard ones that I'll be asking. That being said, as far as the other acts motion, it is your motion, Mr. Verbatim. I've reviewed that. I've reviewed the defendant's response to it. If there's anything you want to add to your motion or highlight.
Thank you, Your Honor. I think the motion clearly articulates what instances of other acts the state proposes to introduce or ask the court to allow the state to introduce in compliance with the statutory requirements under 904.04 sub 2. I think each and every one of them go to an issue of consequence, whether it be, I think they all support intent, identity, lack of mistake, and those things. I would like to note that in reviewing the defense's response to the other acts motion, I think it further supports the appropriateness of the other acts in conjunction with the May 27th, 2020 motion hearing, in that the motion hearing certainly took a tact where the questioning of the officers led to or seemed to try to lead the court to the implication that the drugs were not Miss Bender's, but rather the passenger, Henry Nix. And even though a Denny motion hasn't been filed, it's certainly an implication. And in the response motion, Miss Bender and her attorneys further support that belief when they say, while the defense will certainly draw attention to the lack of investigation related to the passenger and the passenger's access to Miss Bender's purse. Well, there is no other implication. The implication is they're trying to throw the blame on the passenger, even though a Denny motion has not been filed. The motion also seems to imply that two of the events, which are subsequent to the issue in the case at hand, because they're subsequent to them, they shouldn't be considered. However, as I believe the court is familiar with, in State v. Roberson, 157 Wisconsin 2nd, 447, 445, 459 Northwest 2nd, 611, a 1991 Court of Appeals case, the court stated an other act may have occurred before or after the event being litigated. Therefore, it is immaterial whether acts occurred before or after the charged event. So the fact that one event occurred before, one other act occurred before, two occurred after is of no consequence. There's also a talk of the fact that one of the events occurred 9 months before. First of all, I would note that the event was only 7 months before, which isn't completely significant, but it's important to note. But 7 months isn't a long time, and the decision in State v. Spear supports that, wherein the court noted that 2 years was not significant, and State v. Spear is 176 Wisconsin Second, 1101, 501 Northwest Second, 429. A few other notes in the to respond to the defense's response. Um, there's on a number of points or occasions in the motion, they talk about the witnesses being similar. In another act's motion, there's no requirement that the witnesses be the same or similar witnesses. So that's not a basis to not consider or allow in the other act's evidence. Again, the knowledge and intent has been placed at issue, and intent is very important. It's an element of the crime, and the intent of Miss Bender is very important. And I think it's also important to know that while it is the state's burden, the case law clearly in Wisconsin states that um, there are not high hurdles, and they noted in State v. Hammer, 2000, Wisconsin 92, paragraph 30, 236, Wisconsin 2nd, 686, that they don't have events that are sought to be introduced as other acts don't have to be identical. In fact, they stated even dissimilar events and events not near in time could be relevant. And I certainly think in this case, they are relevant. And finally, I will just note that the case law in Whitty notes that convictions aren't mandatory. Prior acts resulting without a conviction are allowed. In State v. Whitty is 34 Wisconsin 2nd, 278, 293, 149 Northwest 2nd, 557, a 1976 Wisconsin Supreme Court case. And based on the state's motion and the supporting case law and a response to the defense's response, I would respectfully request the court to allow those other acts in for the reasons stated in the state's motion. Thank you.
Thank you, Mr. Vervaeten. Ms. Perrin, your response, and Mr. Vervaeten gets the last say since it's his motion.
Thank you, Your Honor. So I want to highlight United States versus Goodwin, 492 F2D 1141 1154, Fifth Circuit, 1974. A prior or subsequent crime or other incident is not admissible for, and in that case, identity, merely because it is similar, but only if it bears such a high degree of similarity as to mark it as the handiwork of the accused. And I think that's the key takeaway the defense has for the defense argument in that regard, that these are generic crimes, that there's no stamp, there's no mark. And so the defense doesn't say the witnesses aren't similar simply to isolate that the witnesses aren't similar, but it's to highlight that there's a list of things that are not similar between these other acts. And in that regard, that is what the defense would ask the court to review and to find ultimately that the state cannot use these other acts. The other issue goes to the fact that this 2019 information, this event, and the 2017 event are events that, well, the 2017 event is charged in 18 CF 25, and the 2019 event remains something that I think, if I recall correctly, the prosecution was saying that they were considering charging. Maybe it's been charged out. I'm not quite sure. But in any event, these cases are not finished yet. And Ms. Bender, in each and every case that she has certain rights. And so what the prosecution is putting Ms. Bender in a situation is to consider whether she gives up her right to remain silent in those cases in this case. And I think that's unfair. I think that is prejudicial. And I would ask the court to deny those two specifically on those grounds. And I would also note, Your Honor, that as the court is certainly aware, there's a greater latitude applied in certain sorts of cases, but not this sort of case. Whereas the court may grant the introduction of other acts in a sexual assault of a child or something like that, when the details aren't as firm or clear, the similarities aren't as firm or clear, that would not be the case in a case like this. And so we do ask the court to once again consider the fact that the state bears the burden. The state cannot point to similarities that make these other acts a stamp, or, you know, would say that specifically, clearly, Ms. Bender has this modus operandi in this case, same thing in that case, same thing in the other case. It simply does not exist between these cases. There is no nexus like that, so we ask the court to deny the state's motion.
And I guess, Ms. Perrin, I just had a question for you regarding one of the things that Mr. Verbatim said, and that was about the defense. And I'm not trying to get you to reveal your defense, because certainly you don't have to do it. But if your tact, or if the tact of defense in this case is, you know, I didn't know it was there, it's not mine, somebody put it in my purse, doesn't that strengthen the state's argument?
Well, Your Honor, first of all, the motion and the witnesses that the state refers to is their witnesses. That the hearing was to suppress evidence that they gathered. If their evidence comes in such a way that they had somebody sitting in the car with access to the purse where the drugs were found, I mean, quite certainly I would be an ineffective attorney not to argue that. However, that does not change the fact that the state has not met their burden in regards to the other acts, in regards to any degree of similarity between the other acts and this particular charge. And so I think it kind of confuses the issue, and the state is trying to put the burden on the defense by saying, well, because she questioned the fact that our officers weren't watching this guy was sitting there with that purse, and lo and behold, the purse had a pile of drugs in it. You know, just because I point that out and make an argument related to that doesn't mean that they don't have to meet their burden. So that is how I would respond to that, Your Honor.
Okay, Mr. Verbatim, you get the last say since it's your motion, but I'd also like you, if you hadn't already thought about it, respond to Ms. Perrin's addition to the Fifth Amendment privilege.
Well, Your Honor, I guess I would note that in State v. Spear, 176 Wisconsin 2nd 1101, that the court noted 90404 sub 2 favors admissibility in the sense that it mandates the exclusion of other crimes evidence in only one instance when it is offered to prove the propensity of the defendant to commit similar crimes. It's not being offered to do that. It's being offered as an acceptable purpose. Motive, not so much motive, but opportunity to have the drugs, intent to sell the drugs, her knowledge and her identity and lack of mistake. In the written argument and in today's argument, clearly, or it certainly seems to be a strong implication that an argument's going to be made that this is a mistake. And for those reasons, I think it's appropriate. I also note that, as the court well knows, the once the first two prongs have been established, and I believe the state has established it, the burden shifts to the defense. I don't believe the defense has established that the evidence is the probative value of the evidence is substantially outweighed by the risk of unfair prejudice. As noted earlier, the hurdles aren't extremely high, and it's one acceptable purpose. It can be all of them or one of them, and if the court finds even just one for each event, it's appropriate to introduce them or allow them to be introduced. With regard to the Fifth Amendment privilege, she's not on trial for the other acts. We don't have to prove the elements of the other acts beyond a reasonable doubt. Therefore, it doesn't implicate her Fifth Amendment. Her Fifth Amendment applies to her decision of whether or not she testifies in this case about the facts in this case, not the other acts evidence. And for those reasons, Your Honor, I'd ask the court to grant the court or the state's motion to introduce the other acts. Thank you.
Thank you, Mr. Verbatim. I've heard the arguments, I've read the legal submissions. First, a couple of issues to just at the outset to address, both brought up by Ms. Perrin. As far as the Goodwin case goes, I'm not so sure that it's good law in the state of Wisconsin, so I'm not convinced it's a federal circuit, not even the Seventh Circuit, that I don't know is, I know it's not applicable in the state of Wisconsin, and I'm not convinced it's even been followed or that logic's been followed in the state of Wisconsin. I think, quite frankly, it's the opposite's been followed. Other acts evidence has been allowed under other circumstances that are both prior to and subsequent to an event or a charge. So I don't think Goodwin is good law in the state of Wisconsin, and certainly I'm not going to follow its analysis because I think it's contrary to what the Wisconsin law is. Second, with regards to the Fifth Amendment privilege, I think you could argue that in every other acts case, that if it hasn't been charged or it's been charged but still pending, it's the same argument, but it's the same decision the defendant has to make whether or not they're going to waive their privilege and testify to the underlying crime or lack thereof, or whether they're going to testify to other acts. So I don't know that there's a distinction or some separate Fifth Amendment privilege analysis that I have to enter into when deciding on another acts evidence. The standard under Sullivan to me is what I have to decide. There's not an additional step of weighing defendant's Fifth Amendment privilege because that's the same whether it's other acts evidence or whether they're deciding to testify after a jury trial. So first of all, the first factor that I have to consider is the acceptable purpose. And to me, that's a no-brainer. I think all three events being discussed have an acceptable purpose. And it is, and I think that the defendant's tactic and defense, as far as it's seeming to me, only solidifies the acceptable purpose. Lack of mistake, knowledge, and intent to me are the acceptable purposes. In particular, and it's particularly strong, I think, in the regarding the 25 file, and that's where there's the delivery allegations that they're seeking to introduce, or the state's seeking to introduce, to show the state does have the burden of proof. And that's where we go to the next step, and whether there's, besides the acceptable purpose, whether it's relevant. And I think the relevancy standard is whether it makes or tends to relate to a fact of consequence to the determination, in this case, of guilt or innocence, and whether there's probative value. And in my opinion, in particular, and I want to analyze the first one, the delivery, the 25 file, which was the delivery file in Ashland County, whether that's, first of all, whether it's to a fact of consequence, and it certainly is. It goes to an element of intent, and to me, that's huge. And again, burden being on the state to prove that. And the second, is there probative value? I think there's significant probative value. And again, that's showing that intent to deliver, as opposed to being potentially just simple possession of it. So I think those two things make it, that standard again weighs in favor of admissibility. And the third being, is the probative value substantial, outweighed by danger of unfair prejudice, confusion of issues, or misleading the jury? And again, I just don't think so. I think there's going to be a jury instruction on it, and it's going to have to be drafted to the party's satisfaction. That's why I have deadlines on jury instructions, so the parties can submit, in this case, an additional other acts evidence instruction. If they want to modify it from the standard, that's fine with me. But I think the probative value is huge. And the prejudice, there's certainly prejudice. Any evidence that the state's seeking to present, I would argue, is prejudicial. The question is whether it's unfairly prejudicial. And in this circumstances, I don't think it's unfairly prejudicial. It really goes to the heart or the elements of the offense, not some type of peripheral issue, which sometimes these, permissible purposes being background, etc., then we have arguments that it's just a peripheral issue, and this goes really to the heart of the evidence. So regarding that, on the 25 file, I'm going to find that other acts evidence can be admitted. That's the delivery. The next is the Washburn County case, 2018 CF 55. In that case, I found already that there's an acceptable purpose, as I found with all three. The next two issues I have to resolve is whether they're relevant, and then whether the probative value is substantially outweighed by the danger of unfair prejudice. And in looking at those factors, first of all, the relevancy standard, and with regards to the Washburn County case, in my opinion, in that case, it is relevant. It is relevant to show, again, what's in, looking at what's in this, as I'm guessing going to be the defense, as even Ms. Parent indicated, it seems to be relevant to show this isn't some type of mistake. And it, again, goes to the intent element, a direct element of the offense, intentionally possessing, so that there's no mistake. And then as far as it being probative, it's, again, probative value is fairly high, not as high, I don't think, as the 25 file, but it's certainly high. And then looking at the final factor, the probative value of being substantially outweighed, in this case, I think, again, the probative value is high. This is something going to show with a possession with intent to deliver. The burden is, there's a lot of intent. You're looking to a person's mind to find intent. And in this case, we have not only the person's mind, or we don't have the person's mind, which we never do, but what we do have is acts that the state believes they can prove to show their intent and knowledge. So again, I think it's highly probative, and it's not, the probative value is high, and the unfair prejudice, in my opinion, is low. Again, when you add in another act's jury instruction. The final one is that January 9th search warrant regarding the possession with intent to deliver potential. And to me, well, there's an acceptable purpose. What I have a problem with in this case is number 2 and 3, and that's whether the evidence relate to a fact or proposition of consequence, and whether there's probative value. And a couple of things, when you're looking at, the search warrant, you're looking at the totality of the circumstances. And now that I've already included 2 other acts evidence, we get to the point where there's a danger of confusion of the issues. And also, I think it's confusing. In that case, it sounds like there'd be evidence where it shows she would be, at least there'd be some circumstantial evidence she'd be using some controlled substance. And in my opinion, this is possession with intent to deliver, not just simple possession. And I don't see how it's going to show, in my opinion, the possession so much with intent to deliver. It may show simple possession, or I guess that she knows what the substance is potentially, but to me it's more confusing. And another factor, I know that Ms. Perrin put it in there, I think the timing of it doesn't really matter so much, but one of the things I can consider when I consider whether it being relevant is, how likely this happened or not. What is the evidence? And this is just a search warrant of an uncharged incident. I don't believe that it's even been charged or to the level of probable cause yet. So I find its probative value very low. And again, when I weigh it against any prejudice, I find prejudice to be very high because I think it's too confusing. There isn't much there to it, and it would be too confusing for the jury. So the final other acts evidence, the January 9th Ashland County search warrant, I'm going to find is not admissible as other acts evidence because I believe the probative value is too low to make it relevant. And I also find that there isn't much, well, there's an acceptable purpose, which again is a low standard. I just don't think it really helps the jury to make the determination of possession with intent. I think it shows maybe possession, or maybe you could argue use, but that's not going to be the question for the jury. The possession with intent is the question. And again, I think it'll be confusing to the jury. So that final other acts evidence I'm finding is not admissible. Mr. Verbate, would you do an order consistent with this opinion? You're on mute still.
Thank you, Your Honor. Yes, Your Honor, I will get that order to you likely tomorrow sometime. Is that acceptable to the court?
That would be great, thank you. Anything else we need to address today, Mr. Verbatim?
Not that I'm aware of, Your Honor. Thank you.
Ms. Perrin, anything else?
No, Your Honor, thank you.
All right, that's it for today. If anything changes or you need to get hold of me or need anything changes, let me know as soon as possible. Thank you.
Your Honor, I'm sorry. I just thought of one thing. The state has filed motions in limine in light of the plan in Ashland County and being off site. My understanding or my interpretation of what the court indicated is that we need to have a motion hearing ahead of time because of the logistics. Is that correct?
And I'm trying to remember what all those motions in limine, I reviewed it at one point, but didn't go into it very far. We can either address those if you want to, or we can look for a date right now and do another Zoom motion for motions in limine, or if it's something that we can do in the transition time over in the courthouse. I just can't remember the motions right off the top of my head. I mean, if they're standard motions,
yes.
I don't know that we need to spend a lot of time on them. We could probably do them during a break, but I just don't remember, Mr. Verbatim.
Well, what I can do is I can discuss that with Ms. Perrin, and if we believe it more efficient to schedule a hearing, we can get a hold of your judicial assistant and Ms. Paddle and schedule that date if that's acceptable to the court and Ms. Perrin.
Sounds like a plan to me, Ms. Perrin. What do you think?
That makes sense to me.
All right, sounds good. Anything else, Ms. Perrin?
No,
All right, thanks. Have a good day.
thank you.
Thank you.